At first glance, this looked like a straightforward sentencing hearing. A convicted felon stood before the court hoping for another chance. His attorney came prepared. Family members wrote letters of support. Friends described him as respectful. The defense argued that prison wasn't the answer. But what happened inside this courtroom would slowly reveal a very different story. And by the end of the hearing, one question would dominate everything. Was this a man trying to rebuild his life? Or was he simply repeating the same pattern that had followed him for years? Welcome back to Verdict Files. Today we're examining a courtroom hearing that begins with hope but quickly turns into something far more complicated. The defendant is Denzel Lewis, a convicted felon charged with unlawful possession of a firearm. On paper, the defense strategy seems simple. Show the judge that Lewis has support. Show the judge that he wants employment. Show the judge that he wants a future outside prison walls. But then something unexpected happened. The judge began asking questions. And those questions started exposing cracks in the defense narrative. The firearm at the center of the case wasn't even the biggest issue anymore. Instead, the hearing became about something much deeper: trust, accountability, and whether the court believed Lewis had truly changed. Could the judge already be seeing through the story? Or was there something much bigger hiding beneath the surface? As the hearing continued, another detail emerged. Lewis claimed the firearm wasn't really his. According to his version, the weapon belonged to someone else. That immediately created a legal problem, because if he truly didn't know about the gun, then why plead guilty? And if he did know about it, then why tell a different story now? This single detail could change everything. The courtroom atmosphere began to shift. What started as a discussion about probation slowly transformed into an examination of credibility. The judge wasn't interested in excuses. The judge wanted consistency, and consistency was becoming increasingly difficult to find. Meanwhile, support letters painted Lewis as a respectful young man, a person deserving another opportunity, a person capable of becoming a productive citizen. But were those letters telling the full story? Or would the court discover something entirely different? As you'll soon see, one set of documents hidden inside the jail records would change the direction of this hearing forever. And once those records were discussed in open court, the possibility of probation began slipping away. But how quickly? And why? Stay with us because the answer reveals exactly how judges evaluate second chances, and why words alone are rarely enough.
Good morning. Are you Melissa Taylor?
Yes, ma'am.
What do you have on your...
Oh, this is my son, Brandon Taylor.
Why'd you wear that this morning?
Because he's my entire world and he's messing me very hard.
Okay. Miss Taylor, this is your initial... No, you were here before. Did you get someone hired?
Ma'am?
Did you get someone hired?
No, I have contacted 4 different attorneys. I have the printout paperwork. I got all the information. They're extremely expensive. I'm not going to get the funds gathered for that.
Who'd you talk to?
I spoke to down
Where?
a month ago.
Where'd you...
Right in the phone.
Okay. Did you talk to some more since that last court date?
The last hearings. You asked, you instructed me to get 3 quotes. That was what I did. I can get that turned into you after.
Okay. If I test you this morning, you can have anything in your system? Have a seat in the jury box. We're going to text. Ms. Taylor, you tested positive for amphetamines, methamphetamines, and ecstasy. And so at this time, I'm going to find that that is a violation, obviously, of your bond conditions. And I'm going to raise your bond in your case to $100,000. Well, let me look at it real quick. I'm going to, let's see. In one of your cases, you're charged with assault on a peace officer, the other credit or debit card abuse. In each of those cases, I'm raising your bond to $100,000 in each case.
Okay.
If you make the bonds in those cases, you are ordered to wear a drug patch at all times, get it tested at the appropriate times, and then we will move forward with your case.
Can I ask a question, please? Am I about to be arrested?
Yeah, you're going into custody right now.
Okay. I have a child.
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff. Go back with the bailiff right now. Go back with the bailiff. Go.
It's missing, and he's with a terrible person.
Sir, you're Denzel Lewis? And Mr. Lewis, you were previously in court, entered a plea of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon. The agreement was for a cap of 6 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Are there any additions or corrections?
Just argument from the defense.
Nothing to say.
In addition, I have received the jail incident reports, which have been turned over to counsel. Have you both had an opportunity to review those?
I have.
Also, I have received this morning and now reviewed, it looks like 4 letters of support that Ms. Holmes brought today. Mr. Smith, have you had an opportunity to review those as well? All right, then Ms. Holmes, you may proceed.
Thank you, Your Honor. In looking at the PSI report, Mr. Lewis does have obviously previous criminal history spanning from juvenile and to adulthood. The priors that he has, it appears, were burglary of a habitation. It looks like 3 cases, but they ran concurrently, in which he was placed on probation and had a revocation, in which he was sentenced to 8 years in TDC. He has since been discharged from that, Your Honor, and after being released, there was this traffic stop, which resulted in a firearm being found in the vehicle in which Mr. Lewis was driving. Obviously, in reading his response to the PSI officer, I would allow him to elaborate more on that. Obviously, he did plead guilty to the offense, taking responsibility, and we are seeking probation in this case, Your Honor. We believe that at this point in Mr. Lewis's life, he understands, obviously, being incarcerated before, that it's not somewhere that he wants to go back and spend potentially 6 additional years of his life. He would like this opportunity on probation to have that opportunity to spend and get back on track with employment, to take care of his family and provide for his family. And reading those support letters, Your Honor, he does have support here from family and friends in the community that are willing to step up and help him to make sure that he is a productive citizen and he gets back on track and understands that there's just certain things with being a convicted felon that he cannot do. And I think at this point he understands that, Your Honor, and we are asking that the court give him the opportunity to be placed on probation and to finish his term while on probation.
Well, I guess before we go any further, I want to make sure I understand, because Mr. Lewis, your version of this is that it wasn't your gun, it was in your girlfriend's, the gun was in the purse in the car. So either you are guilty or you're not guilty of the offense. And so if you knew about it, then you're guilty. If you didn't, then a jury needs to decide.
I'm pleading guilty because I was driving the car, and by me driving and then finding their gun, they
But the law, that's not what the law is. Okay? So you don't get to just take a deal or plead guilty because that's what you want to do. When you were here before, you stood in front of that clerk, you put your hand up, swore that you were going to tell the truth, and I said, are you pleading guilty freely and voluntarily, or are you pleading guilty because you did what they charged you with?
And I was, and I still am.
Okay.
Judge, I think he's been given probation before. It was not successful. He's been revoked. The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
The courtroom atmosphere was beginning to shift. Up until this point, the defense still had a pathway toward probation. Not an easy path, but a path nonetheless. The strategy was clear. Show family support, show rehabilitation, show future potential, and convince the judge that prison would only make things worse. But many viewers may have missed a crucial detail. The judge wasn't focused on what Lewis might do in the future. The judge was focused on what Lewis was doing right now. And that distinction is extremely important. Judges often evaluate risk by looking at current behavior. Not promises, not intentions, not future plans. Current behavior. That means every action taken while awaiting sentencing matters. Every interaction, every disciplinary report, every decision, And now the court was about to compare two completely different versions of Denzel Lewis. Version 1 came from friends and family, a respectful young man, someone deserving another opportunity, someone who had learned from past mistakes. Version 2 came from official jail records, and if those records were accurate, the contrast was devastating. This could become the turning point of the entire hearing, because credibility is everything. If the court stops believing the defendant's version of events, probation becomes incredibly difficult to justify. Notice something else. The judge isn't reading one report. The judge is reading multiple reports, different dates, different officers, different incidents. That matters, because isolated incidents can sometimes be explained away. Patterns are much harder to dismiss. And that's exactly what the judge appears to be identifying. A pattern. If this interpretation is correct, the defense may already be in serious trouble. The question is no longer whether Lewis has support. The question is whether that support accurately reflects reality. And as the reports continue, the answer becomes harder and harder to ignore.
So, Mr. Lewis, one thing I noticed in several of these letters that friends and family members said, I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
Can I speak on the,
Sure.
the case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed up off of my file, but it still shows up. That was not on me. It's somebody.
It's more than one time.
But
So hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then, on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this. Your response, according to this, is that that person should have asked the officers how big your penis, anyway. Since they want to be talking about you, they should have told them about that too. Then, on March 25th, before that, a week, so another officer, and these aren't the same officers, it's not the same person saying the same thing about you, somebody has some vendetta against you. So on March 25th, started to do rounds. Notice that you were watching the person doing rounds, had his hand over his midsection as if he was rubbing on himself. March 18th, another different officer. Notice monitoring the bunk. There you are, laying on your back, stroking your penis in a back and forth motion, told not to do so. January 24th, 2025, you're in trouble for walking around. This one, notice the way you're laying on your bunk in a way, making motions under the blanket, walked past, turned around to see if you were still doing it. Then you supposedly look at this officer and say, "I'm not doing anything," while you lifted the blanket up for that officer to see it. January 4th, another time, being told to be quiet, do what you're supposed to do, didn't do it that day. December 29th, another issue of not following the rules. December 17th, another infraction for arguing and not following the rules. So if there was one time when they got the wrong person, that's one thing. That's over and over again, you disrespecting female officers who are in there just doing their job.
I don't know, sleep on my back.
Sir, we're really gonna do that?
You ask me and I'm mama. I don't do that. Them people write whatever they.
They're making this up on
I don't
you.
have-
That's terrible of them to do that.
If you look at my cases report, ma'am, I don't have any cases on none of that. I don't have any time. I'm not on no restriction on none of that.
Okay.
Up in the county.
You were off parole, the way I do the math, less than a
I was on
year.
parole.
So you did your whole 8 years?
Yes, ma'am.
What'd you do in prison to have to do your whole 8 years?
I was in SIG.
For doing what?
Just tattooing, contraband.
Not following the rules while you're in prison. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you to a term of 6 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal, and you're lucky that this was the agreement. Mr. Smith was generous. The fact is, you could have been enhanced to a second-degree felony because of your history, and you're lucky you weren't. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Ms. Holmes. You can go with the bailiff.
The story of Denzel Lewis is ultimately a story about opportunity. Not one opportunity, multiple opportunities, years of opportunities. The courtroom didn't see a first-time offender. The courtroom saw someone who had already traveled through nearly every stage of the criminal justice system: juvenile supervision, probation, revocation, prison, release, and now another felony conviction. Throughout the hearing, the defense attempted to paint a picture of growth. A man supported by family, a man seeking employment, a man hoping to move forward. And there was evidence supporting that narrative. The support letters were real. The family support appeared genuine. The desire for a better future may very well have been sincere. But the court was forced to evaluate more than hope. The court had to evaluate behavior. Again and again, the judge returned to the same theme: rules, following directions, respect for authority, personal accountability. The firearm charge brought Lewis into the courtroom, but it wasn't what ultimately defined the hearing. Instead, it was everything surrounding the firearm: the conflicting explanations, the prior criminal history, the failed probation, the completed prison sentence, and perhaps most importantly, the jail behavior documented while awaiting sentencing. One by one, those incidents painted a picture the judge could not ignore. To the defense, those incidents may have looked separate and isolated. To the court, they looked like a pattern. And patterns matter, because judges are tasked with predicting risk. No judge can see the future. No judge can know with certainty what someone will do tomorrow. All they can do is examine yesterday and today, and then make the best decision they can. For Lewis, the challenge became overwhelming. The court heard claims of respect, then reviewed allegations of repeated disrespect. The court heard arguments for probation, then reviewed evidence suggesting ongoing rule violations. The court heard promises of change, then reviewed conduct that appeared unchanged. Eventually, the judge reached a conclusion, not because of a single incident, not because of a single report, but because of the total picture. And that total picture convinced the court that prison was the appropriate outcome. The sentence was 6 years, a punishment that could have been even more severe. The judge specifically noted that Lewis avoided additional enhancement possibilities that could have increased the consequences dramatically. For some viewers, the sentence may feel harsh. For others, it may feel justified. And that's what makes cases like this so fascinating. They force us to confront difficult questions. When should someone receive another chance? How many chances are enough? And what evidence truly proves that someone has changed? Those questions don't have easy answers. But inside this courtroom, one thing became clear. The judge believed actions mattered more than promises. And in the end, those actions shaped the outcome.